If you fail to disclose your past medical history, or at least certain details of your past medical history, to your treating doctor, and now you suffer significant harm and injury because of his treatment, when you bring a lawsuit seeking money as a form of compensation against your careless doctor, will it make a difference if you've concealed certain information from him? Would you like to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. I am Gerry Oginski, a New York medical malpractice and personal injury attorney. In my opinion, the answer is most likely yes. It likely will come back to bite you in the butt. And here's why. When you bring a medical malpractice case against a careless doctor, one of the defenses they are going to raise is that you, the patient, caused your own injuries. They will say that you were the ones who contributed to causing your own injuries. And most of the time, most people turn around and say, what are they talking about? How is it possible that I, as the patient, caused my own injuries? In a medical malpractice case, we have to exchange your medical records with the defense. We have to allow them the opportunity to get copies of your medical records from treating doctors that you had before you were treating with the doctor with whom you have sued. Now, they will scour through those records, and they may find certain information in there, so let's say about your past medical history, that the doctor whom you have now sued did not have at the time that he was treating you, for whatever reason. There could be a number of reasons why he did not have it and did not document that information. But now, as one of the defenses that the doctor will raise is, look, had we known this information at the time that we were treating you, we would never have prescribed A, B, and C. We would never have recommended the following treatment. We would never have done the following things. Why? Because it would be contraindicated to do those things if we had known that you had this past history. And the fact that you did not disclose that information to the doctor is on you, Mr. Patient. And now as a result of that, can that hurt you? The answer, most likely in that scenario, absolutely. If you failed to disclose certain information to the doctor about your past history, that could come back to bite you in the butt. But let's delve into that a little bit further. What if you now treat with this particular doctor, you see him for the first visit, and the doctor does not ask you about your past medical history or asks you only one or two questions and you answer the doctor's question? But maybe instead, the doctor never asks you specifics about your past medical history and never followed up asking you additional questions. And now that is the information the doctor claims that you never told them about. Well, who's responsible for that? In all likelihood, it would be the doctor for failing to inquire and to ask you those specific questions. So in the scenario that I've just used, where now the doctor has indicated or he's claimed that you did not disclose certain past history, your past medical history to him, and he's claiming that had you done that, none of your injuries would have occurred because he never would have prescribed certain treatment for you. In that instance, we then have to explore during the course of litigation, during depositions, whether or not the doctor inquired and specifically asked you about your past medical history. Now, past medical history comes up in a number of ways when you see a doctor for the first time. One instance it comes up is in the written questionnaire that you fill out when you're sitting in the waiting room before you get called in to see the doctor. That's one instance. The second instance is where the doctor's assistant now asks you questions before the doctor actually comes into the office. That's a second way. A third way is when the doctor actually comes into the office and starts talking to you and asks you questions about your past medical history, your past surgical history, about your current problems, as well as the physical examination that the doctor will do. So there are multiple ways and multiple times that that information can come up. And if you fail to disclose certain information, you may have a problem. If the nurse or the assistant who comes in to question you fails to obtain that information, that may be a problem for the doctor. If the doctor fails to question you about certain information, likewise, that may be a problem for the doctor if they intend on raising this defense. You, the patient, failed to provide this information to the doctor. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.